What are the elements of false testimony in civil cases? The elements are that the testimony must be given in a civil case, that the testimony must relate to the issues presented in said case, that the testimony must be false, that the false testimony must be given by the defendant knowing it to be false, and 5. That the testimony must be malicious and given with an intent to affect the issues presented in said case. False testimony in other cases and perjury in solemn affirmation. What are the 2 ways of committing perjury? 2 ways of committing perjury. 1. By false testifying under oath. 2. By making a false affidavit. Note: falsely testifying under oath should not be in a judicial proceeding, otherwise it may fall under the crime of false testimony. What are the elements of making a false affidavit? The elements are that the accused made a statement under oath or executed an affidavit upon a material matter, that the statement or affidavit was made before a competent officer authorized to receive and administer oath, that in that statement or affidavit the accused made a willful and deliberate assertion of a falsehood, and 4. That the sworn statement or affidavit containing the falsity is required by law. What is a material matter in relation to the crime of perjury? It is the main fact which was the subject of the inquiry, or any circumstance or fact which tends to prove the fact subject of the inquiry, which tends to corroborate or strengthen the testimony relative to such inquiry, and which legitimately affects the credit of any witness who testifies. Spouses Aboitis versus Spouses Poe. Is good faith or lack of malice available as a defense in perjury and false testimony? Yes. It is required in all these crimes that the offender has knowledge of the falsity or the untruthfulness of the facts he testifies or attests to. Therefore, lack of malice or good faith in believing that the false matters were true can be used as the defense in the imputation of said crimes. People versus Abaya. How is subornation of perjury committed? Subornation of perjury is committed by a person who knowingly and willfully procures another to swear falsely, and the witness suborned thus testify under circumstances rendering him guilty of perjury. U.S. versus Balena. Note: subornation of perjury is not expressly penalized in the RPC, but the direct inducement of a person by another to commit perjury may be punished under Article 183 in relation to Article 17. What are the elements of offering false testimony in evidence? The elements are that the offender offered in evidence a false witness or testimony, that he knew the witness or testimony was false, and 3. That the offer was made in a judicial or official proceeding. Note: Article 184 does not apply when the offender induced a witness to testify falsely. Article 184 applies when the offender knowingly presented a false witness, and the latter testified falsely. The penalty is that for false testimony if committed in a judicial proceeding, and the penalty is that for perjury if committed in other official proceeding. What are the crimes classified as frauds under the RPC? The crimes are 1. Machinations in public auction, Article 185. 2. Monopolies and combinations in restraint of trade, Article 186. Importation and disposition of falsely marked articles or merchandise made of gold, silver, or other precious materials, 187. Substituting and altering trademark and trade names or service marks, Article 188. 5. Unfair competition, fraudulent registration of trade name, trademark, or service mark, fraudulent designation of origin and false description, Article 189. Machinations in public auctions, What are the acts punished under Article 185 of the RPC? Enumerate the elements of each act. The punishable acts are 1. Soliciting any gift or promise as a consideration for refraining from taking part in the public auction. Elements: SRP. That there be a public auction. B. That the accused solicited any gift or a promise from any of the bidders. C. That such gift or promise was the consideration of his refraining from taking part in the public auction. And D. That the accused had the intent to cause the reduction of the price of the thing auctioned. Number 2. Attempting to cause bidders to stay away from an auction by threats, gift, promises, or any artifice. Elements: Patti. A. That there be a public auction. B. That the accused attempted to cause the buyers to stay away from that public auction. C. That it was done by threats, gift, promises, or any other artifice. And D. That the accused had the intent to cause the reduction of the price of the thing auctioned. In soliciting any gift or promise as a form of machination in public auctions, is it required that the person making the proposal actually refrain from taking part in the public auction? What about on the second form of machinations? No. It is consummated by the mere solicitation of gift or promise as a consideration for not bidding. In the second form of machination, which is attempting to cause bidders to stay away from any auction by threats, etc., the crime is consummated by mere attempt. The threat need not be effective, nor the offer or gift be accepted for the crime to arise. Monopolies and combinations in restraint of trade. Q. Is Article 186 of the RPC still a good law? No. Section 55, letter A of RA 10667 of the Philippine Competition Act has expressly repealed Article 186 of the RPC. However, it also provides that violations of Article 186 committed before the effectivity of RA 10667 may continue to be prosecuted unless the same have been barred by prescription and subject to the procedure under Section 31 of the same Act. Therefore, it is not completely inoperative. What are the acts which are punishable under the crime of monopolies and combinations in restraint of trade? The punishable acts are: 1. Combination or conspiracy to prevent free competition in market by entering into any contract or agreement or taking part in any conspiracy or combination in the form of a trust or otherwise, in restraint of trade or commerce, or to prevent by artificial means free competition in the market. 2. Monopoly to restrain free competition in market by monopolizing any merchandise or object of trade or commerce, or by combining with any other person or persons to monopolize said merchandise or object in order to alter the prices thereof by spreading false rumors and making use of any other artifice to restrain free competition in the market. And 3. Making transactions prejudicial to lawful commerce or to increase the market price of merchandise. Note: only property possessed under any contract or combination shall be forfeited to the government. RPC Article 186 Number 3. Who may be liable for monopolies and combinations? The persons liable are: 1. Manufacturer, 2. Producer, 3. Processor, and 4. Importer. Section 2. Frauds in Commerce and Industry. What are the elements of Article 187 of the RPC? The elements are: Isa. 1. That the offender imports, sells, or disposes any of those articles. Number 2. That the stamps, brands, or marks of those articles or merchandise fail to indicate the actual fineness or quality of said metal or alloy. And 3. That the offender knows that the stamps, brands, or marks fail to indicate actual fineness or quality of said metal or alloy. Note: selling the misbranded articles is not necessary. Article 187 does not apply to the manufacturer of misbranded articles. The manufacturer is liable for estafa under Article 315, Subdivision Number 2, Letter B of the RPC. Crimes against public morals. What are the crimes against public morals under the RPC? The following are the crimes against public morals. Pig. 1. Grave scandal, Article 200. Number 2. Immoral doctrines, obscene publications, and exhibitions, and indecent shows, Article 201. 3. Prostitution. Chapter 2. Offenses against decency and good customs. What is grave scandal? It consists of acts which are offensive to decency and good customs, which, having been committed publicly, have given rise to public scandal to persons who have accidentally witnessed the same. What are the elements of grave scandal? The following are the elements of grave scandal: that the offender performs an act or acts, that such act or acts be highly scandalous, as offending against decency or good customs. 3. That the highly scandalous conduct is not expressly falling within any other article of the RPC. Number 4. That the act or acts complained of be committed in a public place or within the public knowledge or view. U.S. v. Samaniego. Note: even if the Article 200 does not so express, it is evident that a condition precedent for the existence of this crime, the offense against decency and good customs, must have been made public. If the offense does not have this element, it is clear that it does not produce the grave scandal required by Article 200. U.S. v. Kata J. Immoral doctrines, obscene publications and exhibitions, and indecent shows. Who are the persons liable under Article 201? The following persons may be liable under Article 201: those who shall publicly expound or proclaim doctrines openly contrary to public morals. 2. The authors of obscene literature, published with their knowledge in any form, the editors publishing such literature, and the owners or operators of the establishment selling the same. Number 3. Those who in theaters, fairs, and cinematographs, or any other place, exhibit indecent or immoral shows, which are proscribed or are contrary to the morals, good custom, established policies, lawful orders, decrees, and edicts. And number 4, those who shall sell, give away, or exhibit films, prints, engravings, sculpture, or literature which are offensive to morals. Note: publicity is essential to the crime. What is the test of obscenity? The test is whether the tendency of the matter charged obscene is to deprave or corrupt those whose minds are open to such immoral influences, and into whose hands such a publication may fall, and also whether or not such publication or act shocks the ordinary and common sense of men as an indecency. Indecency is an act against the good behavior and a just delicacy. U.S. v. Kattinger. Is the mere possession of obscene materials punishable? No. Mere possession without intention to sell, exhibit, or give away is not punishable under Article 201, considering that the purpose of the law is to prohibit dissemination of obscene materials to the public. Fernando v. Court of Appeals. Prostitutes. Distinguished Article 202 of the RPC and RA 9208, which punishes the trafficking of persons, including prostitutes. Article 202 punishes the prostitutes themselves for willingly offering sexual services to the public. Pimps and persons engaged in the trafficking of persons or facilitates prostitutions are punished under RA 9208, Anti-Trafficking in Persons Act of 2003. Under the revised Penal Code, what are the crimes committed by public officers under the RPC? The following are the crimes committed by public officers. 1. Knowingly rendering an unjust judgment. 204. Judgment rendered through negligence. 205. Unjust interlocutory order. 206. Malicious delay in the administration of justice. 207. Negligence or tolerance in the prosecution of offenses. 208. Betrayal of trust by an attorney or solicitor. 209. Bribery. 210. Indirect bribery. 211. Corruption of public officials. 212. Frauds against the public treasury and similar offenses. 213. Other frauds. 214. Prohibited transactions. 215. Possession of prohibited interest by a public officer. 216. Malversation of public funds or property. 217. Failure of accountable officers to render accounts. 218. Failure of a responsible public officer to render accounts before leaving the country. 219. Illegal use of public funds or property. 220. Failure to make delivery of public funds or property. 221. Conniving with or consenting to evasion. 223. Evasion through negligence. 224. Escape of prisoner under the custody of a person not a public officer. 225. Removal, concealment, or destruction of documents. 226. Officer breaking seal. 227. Opening of closed documents. 228. Revelation of secrets by an officer. 229. Public officer revealing secrets of private individual. 230. Open disobedience. 231. Disobedience to order of superior officers when said order was suspended by inferior officer. 232. Refusal of assistance. 233. Refusal to discharge elective office. 234. Maltreatment of prisoners. 235. Anticipation of duties of a public office. 236. Prolonging performance of duties and powers. 237. Abandonment of office or position. 238. Usurpation of legislative powers. 239. Usurpation of executive powers or functions. 240. Usurpation of judicial functions. 241. Disobeying request for disqualification. 242. Orders or requests by executive officers to any judicial authority. 243. Unlawful appointments. 244. Abuses against chastity. 245. Public officers. What are the elements of one to be considered a public officer? PA. The following are the elements of one to be considered as a public officer. 1. Taking part in the performance of public functions in the government or performing in said government or in any of its branches, public duties as an employee, agent, or subordinate official, or any rank or class. And 2. That his authority to take part in the performance of public functions or to perform public duties must be direct provision of law, by popular election, by appointment of competent authority. No, the term public officers embraces every public servant from the highest to the lowest. For the purposes of the RPC, it obliterates the standard distinction in the law of public officers between officer and employee. Temporary performance of public functions by a laborer makes him a public officer. Maniego versus People. What is misfeasance? It is the improper performance of some act which might lawfully be done. What is malfeasance? It is the performance of some act which ought not to be done. What is nonfeasance? It is the omission of some act which ought to be performed. What are the elements of knowingly rendering unjust judgment? The following are the elements: that the offender is a judge, that he renders a judgment in a case submitted to him for decision, that the judgment is unjust, that the judge knows that his judgment is unjust. What is a judgment? A judgment is the final consideration and determination of a court of competent jurisdiction upon matters submitted to it, in an action or proceeding. What is an unjust judgment? It is one which is manifestly contrary to law or is not supported by evidence or both. Note, there must be evidence that the judgment is unjust. It cannot be presumed. Furthermore, Article 204 does not apply to members of a collegiate court. What are the elements of judgment rendered through negligence? The following are the elements for the crime of judgment rendered through negligence: that the offender is a judge, that he renders a judgment in case submitted to him for decision, that the judgment is manifestly unjust, and that it is due to his inexcusable negligence or ignorance. RPC 205. Note, mere error of judgment cannot serve as basis for a charge of knowingly rendering an unjust judgment, where there is no proof or even allegation of bad faith or ill motive or improper consideration. Yaranon v. Judge Rubio. What are the elements of unjust interlocutory order? The following are the elements of the crime of unjust interlocutory order. PJ. That the offender is a judge, that he performs any of the following acts. MK. Knowingly rendering unjust interlocutory order or decree, or rendering a manifestly unjust interlocutory order or decree through inexcusable negligence or ignorance. 206. What are the elements of malicious delay in the administration of justice? That the offender is a judge, that there is a proceeding in his court, that he delays the administration of justice, that the delay is malicious. That is, the delay is caused by the judge with deliberate intent to inflict damage on either party in the case. What are the punishable acts under Article 208? The following are the punishable acts under Article 208: maliciously refraining from instituting prosecution against violators of the law, and 2. Maliciously tolerating the commission of offenses. What are the elements of dereliction of duty in the prosecution of offenses? The following are the elements of dereliction of duty in the prosecution of offenses. DNA. That the offender is a public officer or officer of the law who has a duty to cause the prosecution of or to prosecute offenses. 2. That there is dereliction of the duties of his office. Knowing the commission of the crime, he does not cause the prosecution of the criminal, or knowing that a crime is about to be committed, he tolerates his commission. And 3. That the offender acts with malice and deliberate intent to favor the violator of the law. An officer of the law under Article 208 includes all those who, by reason of the position held by them, are duty-bound to cause the prosecution and punishment of the offenders. However, this article is not applicable to officers, agents, or employees of the Bureau of Internal Revenue who, having knowledge or information of a violation of the Internal Revenue Law, fails to report such matters to their superiors, as they shall be punished under the law, not under this provision. Betrayal of trust by an attorney or solicitor, revelation of secrets. What are the punishable acts under Article 209? The following are the punishable acts under Article 209, CRU. 1. Causing damage to his client either by any malicious breach of professional duty or by inexcusable negligence or ignorance. Revealing any of the secrets of his client learned by him in his professional capacity, and undertaking the defense of the opposing party in the same case without the consent of his first client, after having undertaken the defense of said first client, or after having received confidential information from said client. Note: in the first punishable act, damage to the client is necessary, while in the second, damage is immaterial. On the other hand, under the third punishable act, if the client consents to the attorney's taking the defense of the other party, there is no crime. Bribery, direct bribery. What are the punishable acts in the direct bribery? The following are punishable acts in direct bribery: agreeing to perform, or by performing, in consideration of any offer, promise, gift, or present, an act constituting a crime in connection with the performance of his official duties. Number 2. Accepting a gift in consideration of the execution of an act which does not constitute a crime in connection with the performance of his official duty, and 3. Agreeing to refrain or from refraining from doing something which is his official duty to, in consideration of gift or promise. What are the elements of direct bribery? That the offender be a public officer within the scope of Article 203, that the offender accepts an offer or a promise or receives a gift or present by himself or to another, that such offer or promise be accepted or a gift or present received by the public officer, with a view to committing some crime, in consideration of the execution of an act which does not constitute a crime, but the act must be unjust, or C. to refrain from doing something which is his official duty to do, and 4. that the act which the offender agrees to perform or which he executes be connected with the performance of his official duty. What is the difference between the third form of direct bribery and prevarication or dereliction of duty under Article 208? As to the manner of commission, both crimes are committed by refraining from doing something which pertains to the duty of the officer. However, they differ as to consideration. In the third form of bribery, the offender must have refrained from doing his official duty in consideration of a gift received or promised, while in prevarication or prevarication, gift or consideration is not essential. Is direct bribery committed if the gift is solicited by the public officer rather than offered by the party seeking favor? Yes, the crime of bribery is also committed when the gift is solicited by a public officer, as the consideration of his refraining from the performance of an official duty, and the private person gives the gift for the fear of the consequences which would result if the officer performs his function. People versus Sope. Indirect bribery. What are the elements of indirect bribery? The following are the elements of indirect bribery. Pugo. That the offender be a public officer, that he accepts gifts, and that the said gifts are offered to him by reason of his office. Note, there is no attempted or frustrated indirect bribery, because it is committed by accepting gifts offered to the public officer by reason of his office. If he does not accept the gift, he does not commit the crime. If he accepts the gifts, it is consummated. Mere promise or offer are not sufficient to constitute indirect bribery. Formulesa versus Sandiganbayan. If after receiving the gift he does not act in favor of the giver, it ceases to be indirect, but becomes direct bribery. Boado. Notes and cases on the RPC. What is the difference between the third form of direct bribery and indirect bribery? They are different that in direct bribery, a public officer receives a gift by reason of an agreement between him and the giver of the gift or present to perform an act or refrain from doing something by reason of such gift or promise. On the other hand, in indirect bribery, there usually exists no such agreement, and it is not necessary that the officer should do any particular act or even promise to do an act. It is enough that he accepts gifts offered to him by reason of his office. Is the receiving of gifts by public official and giving of gifts by private persons on any occasion, including Christmas, punishable? Yes. It is punishable if such gift is given by reason of the public official's position, regardless of whether or not. The same is for past favor or favors of the giver hopes or expects to receive a favor or better treatment in the future from the public official or employee concerned in the discharge of his official functions. Note, included within the prohibition is the throwing of parties or entertainments in honor of the official or employee or of his immediate relatives. What are the elements of qualified bribery? The following are the elements of qualified bribery. LAP. That the offender is a public officer entrusted with law enforcement. That the offender refrains from arresting or prosecuting an offender who has committed a crime punishable by reclusion perpetua and or that, and that the offender refrains from arresting or prosecuting the offender in consideration of any promise, gift, or present. RPC Article 211-A. What are the elements of corruption of public officials? The following are the elements of corruption of public officials. OG. That the offender makes offers or promises or gives gifts or presents to a public officer, and 2. That the offers or promises are made or the gifts or presents given to a public officer under circumstances that will make the public officer liable for direct bribery or indirect bribery. When is the corruption of public officials consummated? It is consummated when the gift or present is accepted by the public official. However, it is only in its attempted stage if the said offer is refused. Poser v. Court of Appeals. May a giver of bribes and his accomplices be immune from prosecution? Yes, if they willingly testify against public officers or employees in bribery and other grave cases. However, the following conditions must be satisfied for the immunity to be enjoyed. PD 749. 1. The information must refer to consummated violations of any of the provisions of law, rules, and regulations mentioned in PD 749. Number 2. That the information and testimony are necessary for the conviction of the accused public officer. Number 3. Such information and testimony are not yet in possession of the state. Such information and testimony can be corroborated on its material points. And 5. The informant or witness has not been previously convicted of a crime involving moral turpitude. What are the acts punishable under Article 213? The following are the acts punishable under Article 213. 1. Entering into an agreement with any interested party or speculator or making use of any other scheme to defraud the government in dealing with any person with regard to furnishing supplies, the making of contracts, or the adjustment or settlement of accounts relating to public property or funds. 2. Demanding directly or indirectly the payment of sums different from or larger than those authorized by law in the collection of taxes, licenses, fees, and other imposts. 3. Failing voluntarily to issue a receipt as provided by law or any sum of money collected by him officially in the collection of taxes, licenses, fees, and other imposts. And 4. Collecting or receiving directly or indirectly by any way of payment or otherwise things or objects of a nature different from that provided by law in the collection of taxes, licenses, fees, and other imposts. What are the elements of frauds against public treasury? Paragraph 1. The following are the elements of frauds against public treasury, PTED. That the offender is a public officer, that he should have taken advantage of his office, that is, he intervened in the transaction in his official capacity, that he entered into an agreement with any interested party or speculator or made use of any other scheme with regard to furnishing supplies, the making of contracts, or the adjustment or settlement of accounts relating to public property or funds, and 4. That the accused had intent to defraud the government. What are the elements of illegal exactions? Paragraph 2 to 4. The following are the elements of illegal exactions: that the offender is a public officer entrusted with the collection of taxes, licenses, fees, and other imposts, and he is guilty of any of the following acts or omissions: demanding, directly or indirectly, the payment of sums different from or larger than those authorized by law, failing voluntarily to issue a receipt as provided by law for any sum of money collected by him officially. C. Collecting or receiving, directly or indirectly, by way of payment or otherwise, things or objects of a nature different from that provided by law. No, when there is deceit in demanding greater fees than those prescribed by law, the crime committed is estafa and not illegal exaction. Other frauds. What are the elements of other frauds? The following are the elements of other frauds, PTA: that the offender is a public officer, that he takes advantage of his official position, and 3. That he commits any of the frauds or deceits enumerated in Article 315 to 318. A. 315 estafa. B. 316 other forms of swindling, 317 swindling a minor, 318 other deceits. Note, if a public officer takes advantage of his public position to commit the acts punished under Article 315 to 318, the fact that he is a public officer shall not be considered merely as an aggravating circumstance under Article 14, number 1, and Article 62, number 1A. Instead, the acts are punished as a separate felony under Article 214. What are the elements of prohibited transactions? The following are the elements of prohibited transactions, ATTI. That the offender is an appointive public officer, that he becomes interested directly or indirectly in any transaction of exchange or speculation, that the transaction takes place within the territory subject to his jurisdiction, and that he becomes interested in the transaction during his incumbency. No, purchasing of stocks or shares in a company is simply an investment and is not a violation of Article 215, but buying regularly securities for sale is speculation. Who may be held liable under Article 216? Possession of prohibited interest by a public officer. The following are persons who may be liable under Article 216. 1. Public officers who directly or indirectly became interested in any contract or business in which it was his official duty to intervene. 2. Experts, arbitrators, and private accountants who in like manner took part in any contract or transaction connected with the state or property in the appraisal, distribution, or adjudication of which they had acted. And 3. Guardians and executors with respect to the property belonging to theirs, wards, or the state. Note, actual fraud is not necessary. The act is punished because of the possibility that fraud may be committed, or that the officer may place his own interest above that of the government or party which he represents. U.S. v. Udarbe. Chapter 4. Malversation of public funds or property. Malversation of public funds or property. Presumption of malversation. What are the acts punishable in malversation? The following are the acts punishable in malversation. 1. Appropriating public funds or property. 2. Taking or misappropriating the same. 3. Consenting or through abandonment or negligence permitting any other person to take such public funds or property. And 4. Being otherwise guilty of the misappropriation or malversation of such funds or property. What are the common elements to all acts of malversation in Article 217? The following are the common elements to all acts of malversation in Article 217. That the offender be a public officer, that he had custody or control of funds or property by reason of the duties of his office, that those funds or property were public funds or property for which he was accountable, and 4. That he appropriated, took, misappropriated, or consented, or through abandonment or negligence permitted another person to take them. Note, damage to the government is not necessary. The mere fact that the accused has committed breach of faith is prejudicial to the best interest of the service as public office is public trust. Is demand necessary in malversation? No. Demand merely raises a prima facie presumption that missing funds have been put to personal use. The demand itself, however, is not an element of and not indispensable to constitute malversation. Venezuela versus People. What is the presumption if the public officer fails to have duly forthcoming public funds or property with which he is chargeable upon demand by any duly authorized officer? It shall be a prima facie evidence that he has put such missing funds or property to personal uses. An accountable officer may be convicted of malversation even if there is no direct evidence or misappropriation, and the only evidence is that there is shortage in his accounts, which he has not been able to explain satisfactorily. Perez versus People. If the accused has adduced evidence showing that he did not put the missing funds or property to personal uses, then that presumption is at an end, and the prima facie case is destroyed. May malversation be committed by private individuals? Give the instances. Yes, malversation may be committed by private individuals in the following instances. 1. Those in conspiracy with an accountable public officer found guilty of malversation. Soleta versus Sandigan Bayan. Number 2. Under Article 222, the provisions of Article 217 shall apply to private individuals who, in any capacity whatsoever, have charge of national, provincial, or municipal funds, revenues, or property, and b. any administrator or depositary of funds or property attached or seized or deposited by public authority. What are the elements of failure of accountable officer to render accounts? Part 1. That the offender is a public officer, whether in the service or separated therefrom. That he must be an accountable officer for public funds or property. That he is required by law or regulation to render accounts to the Commission of Audit or to a provincial auditor. And 4. That he fails to do so for a period of 2 months after such accounts should be rendered. Note: demand and misappropriation are not necessary. If there is misappropriation, he would also be liable for malversation. Article 217. What are the elements of failure of a responsible public officer to render accounts before leaving the country? The following are the elements of failure of a responsible public officer to render accounts before leaving the country. PAU. That the offender be a public officer. That he must be an accountable officer for public funds or property. And 3. That he must have unlawfully left or be on the point of leaving the Philippines without securing from the COA a certificate showing that his accounts have been finally settled. What are the elements of illegal use of public funds or property? The following are the elements of illegal use of public funds or property. That the offender be a public officer. That there is a public fund or property under his administration. That such public fund or property has been appropriated by law or ordinance. And 4. That he applies the same to a public use other than that for which such fund or property has been appropriated by law or ordinance. Distinguish illegal use of public funds or property from malversation under Article 217. The following are the difference between illegal use of public funds or property and malversation. Illegal use of public funds or property as to who may commit. Offenders are accountable public officers. As to the profit obtained, the offender does not derive any personal gain or profit. As to the subject matter, the public fund or property is applied to another public use. Malversation. As to who may commit, offenders are accountable public officers. As to the profit obtained, the offender in certain cases profits from the proceeds of the crime. As to the subject matter, the public fund or property is applied to the personal use and benefit of the offender or of another person. Note: technical malversation is not included in, nor does it necessarily include a crime of malversation of public funds. What are the punishable acts under Article 221, failure to make delivery of public funds or property? The following are punishable acts under Article 221. 1. Failing to make payments by a public officer who is under obligation to make such payment from government funds in his possession. And 2. Refusing to make delivery by a public officer who has been ordered by competent authority to deliver any property in his custody or under his administration. What are the elements of failure to make payment? Paragraph 1. The following are the elements of failure to make payments. Fog. That the public officer has government funds in his possession, that he is under obligation to make payments from such funds, and that he fails to make the payment maliciously. Who are the private individuals that may be held liable under Article 217 to 221? The following private individuals may be liable under Article 217 to 221. 1. Private individuals who, in any capacity whatsoever, have charge of any national, provincial, or municipal funds, revenue or property, and 2. Administrator or depository of funds or property attached, seized, or deposited by public authority, even if such property belongs to a private individual. Chapter 5. Infidelity of Public Officers. What are the elements of Article 223? The following are the elements of 223. That the offender is a public officer, that he had in his custody or charge a prisoner, either detention prisoner or prisoner by final judgment, that such prisoner escaped from his custody, that he was in connivance with the prisoner in the latter's escape. Alberta versus De La Cruz. Note, there is real and actual evasion of service of sentence when the custodian permits the prisoner to obtain a relaxation of his imprisonment and to escape the rigors of punishment, of being deprived of his liberty, thus making the penalty ineffectual, although the convict may not have fled. Evasion through negligence. What are the elements of Article 224? The following are the elements of Article 224. That the offender is a public officer, that he is charged with the conveyance or custody of a prisoner, either detention prisoner or prisoner by final judgment, and that, number 3, such prisoner escaped through his negligence. Note, if the prisoner escapes through the negligence of the public officer, the latter suffers the same penalty regardless of whether the prisoner is a convict or merely a detention prisoner. Not every negligence or distraction of a guard is penalized. It is only that positive carelessness that is short of deliberate non-performance of his duties as guard that is the gravamen of the crime of infidelity. Article 224. What is the liability of the escaping prisoner? His liability shall be as follows. 1. If the fugitive is serving sentence by reason of final judgment, he is liable for evasion of the service of sentence under Article 157. If the fugitive is only a detention prisoner, he does not incur criminal liability. Escape of prisoner under the custody of a person not a public officer. What are the elements of Article 225? That the offender is a private person. That conveyance or custody of a prisoner or person under arrest is confided to him. That the prisoner or person under arrest escapes. And 4. That the offender consents to the escape of the prisoner or person under arrest, or that the escape takes place through his negligence. Note, Article 225 is not applicable if a private person was the one who made the arrest and he consented to the escape of the person he arrested. What are the acts punishable in infidelity in the custody of documents? The punishable acts are 1. By removing, 2. By destroying, and 3. By concealing documents or papers officially entrusted to the offending public officer. Removal, concealment, or destruction. What are the elements of removal, concealment, or destruction of documents? The following are the elements of Article 226. That the offender be a public officer, that he obstructs, destroys, or conceals documents or papers, that the said documents or papers should have been entrusted to such public officer by reason of his office, and 4. That the damage, whether serious or not, to a third party or to the public interest should have been caused. When is it consummated? It is consummated when the public document is removed or secreted away from its usual place in the office and after the offender had gone out and locked the door, it being immaterial whether he has or has not actually accomplished the illicit purpose of which he removed said document. Cataniag versus People. Officer breaking seal. What are the elements of officer breaking seal? The following are the elements of Article 227. That the offender is a public officer, that he is charged with the custody of papers or property, that these papers or property are sealed by proper authority, and that he breaks the seals or permit them to be broken. Note, damage or intent to do damage is immaterial. Opening of closed documents. What are the elements of opening of closed documents? The following are the elements of Article 228. That the offender is a public officer, that any closed papers, documents, or objects are entrusted to his custody, that he opens or permits to be opened said closed papers, documents, or objects, and that he does not have proper authority. What if, in opening the closed papers or objects, the public officer broke the seal? The offense committed would be breaking seal, because breaking the seal is the operative act that opens the closed document. Article 228 contemplates documents which are closed or classified but not necessarily sealed. Section 3. Revelation of secrets. Revelation of secrets by an officer. What are the punishable acts under Article 229? The following are the punishable acts under Article 229. 1. Revealing any secrets known to the offending public officer by reason of his official capacity. And 2. Delivering wrongful papers or copies of papers of which he may have charge and which should not be published. What are the elements of revealing of secrets by public officer? The elements are as follows: that the offender is a public officer, that he knows of a secret by reason of his official capacity, that he reveals such secret without authority or justifiable reasons, and 4. That damage, great or small, be caused to the public interest. Note: secret of private individuals are not included. What are the elements of wrongful delivery of papers? The elements are as follows: that the offender is a public officer, that he has charge of papers, that those papers should not be published, that he delivers those papers or copies thereof to a third person, that the delivery is wrongful, and 6. That damage be caused to public interest. Note: if the papers contain secrets and therefore should not be published, and the public officer having charge thereof removes and delivers them wrongfully to a third person, the crime is revelation of secrets by a public officer. Public officer revealing secrets of private individual. What are the elements of public officers revealing secrets of private individual? The following are the elements of Article 230. That the offender is a public officer, that he knows of the secret of a private individual by reason of his office, and that he reveals such secrets without authority or justifiable reason. Note: revelation to one person is sufficient, for public revelation is not required. Is damage to the private individual necessary? No. The reason for this provision is to uphold faith and trust in public service. Is Article 230 applicable to an attorney at law or a solicitor? No. If he reveals the secret of his client learned by him in his professional capacity, he is liable under Article 209, betrayal of trust by an attorney or solicitor. Chapter 6, Section 1, Disobedience, Refusal of Assistance, and Maltreatment of Prisoners. Open disobedience. What are the elements of open disobedience? The following are the elements: that the offender is a judicial or executive officer. 2. That there is a judgment, decision, or order of a superior authority. 3. That such judgment, decision, or order was made within the scope of the jurisdiction of the superior authority and issued with all the legal formalities. 4. That the offender, without any legal justification, openly refuses to execute the said judgment, decision, or order of any superior authority. What are the elements of Article 223? Disobedience to order of superior officer when said order was suspended by inferior office. 1. That the offender is a public officer. 2. That there is an order issued by his superior for execution, that he has for any reason suspended the execution of such order, that his superior disapproves the suspension of the execution of the order, and 5. That the offender disobeys his superior despite the disapproval of the suspension. Note: Article 232 does not apply if the order of the superior is illegal. Refusal of assistance. What are the elements of refusal of assistance? The following are the elements of refusal of assistance: that the offender is a public officer, that a competent authority demands from the offender that he lends his cooperation towards the administration of justice or other public service, and 3. That the offender fails to do so maliciously. Note: damage to the public interest or to a third party is essential to the crime. Refusal to discharge elective office. What are the elements of refusal to discharge elective office? That the following are the elements of refusal to discharge elective office. that the offender is elected by popular election to a public office, that he refuses to be sworn in or to discharge the duties of said office, and that there is no legal motive for such refusal to be sworn in or to discharge the duties of said office. Maltreatment of prisoners. What are the elements of maltreatment of prisoners? The following are the elements of maltreatment of prisoners: that the offender is a public officer or employee, that he has under his charge a prisoner or detention prisoner, and that he maltreats such prisoner in either of the following manner: by overdoing himself in the correction or handling of a prisoner or detention prisoner under his charge, either by the imposition of punishment not authorized by the regulations, or by inflicting such punishments, those authorized in a cruel and humiliating manner, or b. by maltreating such prisoner to extort a confession or to obtain some information from the prisoner. Note: the offender is also liable for physical injuries, as Article 235 states that the penalty to be imposed is in addition to his liability for the physical injuries or damage caused. Hence, there is no complex crime of maltreatment of prisoners with serious or less serious physical injuries, as defined in Article 48. Section 2. Anticipation, prolongation, and abandonment of the duties and powers of public office. What are the elements of anticipation of duties of a public office? That the offender is entitled to hold a public office or employment, either by election or appointment, that the law requires that he should first be sworn in and or should first give a bond, that he assumed the performance of the duties and powers of such office, and that he has not taken his oath of office and or given the bond required by law. Prolonging performance. What are the elements of prolonging performance of duties and powers? That the following are the elements of prolonging performance of duties and powers: that the offender is holding a public office. 2. That the period provided by law, regulations, or special provisions for holding such office has already expired. And 3. That he continues to exercise the duties and powers of such office. Note: a public officer who has been suspended, separated, declared overaged, or dismissed cannot continue to perform the duties of his office. Abandonment of office or position. What are the elements of abandonment of office or position? That the offender is public officer, that he formally resigns from his position, that his resignation has not yet been accepted, and that he abandons his office to the detriment of the public service. Note: the offense is qualified if the abandonment has for its purpose to evade the discharge of the duties of preventing, prosecuting, or punishing any of the crimes falling within Title I and Chapter 1 of Title III of Book 2 of the RPC, Article 238. Distinguish abandonment of office from negligence and tolerance in prosecution of offenses. That's Article 238 and Article 208. Article 238 is committed by any public officer who abandons his office to evade the discharge of his duties. Article 208 is committed only by a public officer who is charged with the duty to institute prosecution for violation of the law, and he fails to prosecute such by dereliction of duty or by malicious tolerance of the commission of the offense. Section 3. Usurpation of legislative powers. What are the elements of usurpation of legislative powers? The following are the elements of usurpation of legislative powers: that the offender is a judicial or executive officer, and that he makes general rules and regulations beyond the scope of his authority. B. Attempts to repeal a law. C. Suspends the execution thereof. Usurpation of executive functions. What are the elements? The following are the elements of usurpation of executive functions: that the offender is a judge, and that he assumes a power pertaining to the executive authorities, or b. obstructs the executive authorities in the lawful exercise of their powers. Usurpation of judicial function. That the offender is an officer of the executive branch of the government, and that he assumes judicial powers or B. Obstructs the execution of any order or decision rendered by any judge within his jurisdiction, disobeying requests for disqualification. The following are the elements of disobeying requests for disqualification: that the offender is a public officer, that a proceeding is pending before such public officer, that there is a question brought before the proper authority regarding his jurisdiction, which is not yet decided, that he has been lawfully required to refrain from continuing the proceeding, and that he continues the proceeding. What are the elements of orders or requests by executive officer to any judicial authority? The following are the elements: that the offender is an executive officer, that he addresses any order or suggestions to any judicial authority, and 3. That the order or suggestion relates to any case or business coming within the exclusive jurisdiction of the courts of justice. Unlawful appointments. What are the elements of unlawful appointments? That the offender is a public officer, that he nominates or appoints a person to a public office, that such person lacks the legal qualifications thereof, and 4. That the offender knows that his nominee or appointee lacks the qualifications at the time he made the nomination or appointment. Section 4. Abuses against chastity. What are the ways of committing abuses against chastity? 1. By soliciting or making immoral or indecent advances to a woman interested in matters pending before the offending officer for decision, or with respect to which he is required to submit a report or consult with a superior officer. B. By soliciting or making immoral or indecent advances to a woman under the offender's custody, or 3. By soliciting or making immoral or indecent advances to the wife, daughter, sister, or relative within the same degree by affinity of any person in the custody of the offending warden or officer. What are the elements of abuses against chastity? That the offender is a public office, that he solicits or makes immoral or indecent advances, and note, solicit means to propose earnestly and persistently something unchaste and immoral to a woman, that such woman must be A. Interested in matters pending before the offending officer for decision, or with respect to which he is required to submit a report or consult with a superior officer. B. Under the custody of the offender, who is a warden or other public officer directly charged with the care and custody of prisoner or persons under arrest. Or C. The wife, daughter, sister, or relative within the same degree of affinity of any person in the custody of the offender. Note: the mother of the person in the custody of the offender is not included. Mere proposal consummates the offense.